We spent 3 days talking about 5-minute video, right? And now 2 hours of closing arguments talking about 5-minute video. That was 45 minutes of the gymnastics you basically have to go to ignore what you saw with your own eyes and to ignore what the judge will tell you the law is. That's what that was. You can say all day, this is what you would have done, or the defendant is the real victim here. Are you kidding me? He's a victim? 2 people are dead.
Objection, Your Honor. That's never made an argument that it was a big response.
That's absolutely a reasonable interpretation of what we just spent a long time doing. That acted appropriately. He was faced with a situation where he got killed, I think it's a reasonable response to that argument. Yeah. 2 people are dead. 2 people are no longer with us. Anisha woke up that day expecting to go to bed that night in her own bed. Turner woke up that day expecting to spend it with his family and go to bed that night in his own bed. They're both deceased because of him. He's the reason we're all in this courtroom today. Legally, factually. That's it. The judge will read you the law, has read you the law, you have copies. Please, please, please read that back in the jury room. These legal concepts are not controversial. They're not new. They're given to us by the legislature to hold people accountable in situations like this. And it's as simple as, under accomplice liability theory, the evidence need not show that the accomplice personally participated in the commission of each element of a particular offense. These 3 people went to this house together. When Anisha and the defendant got out of the car, Anisha, who sadly is deceased, was the driver. She's a getaway driver. They knew that something might happen that would cause them to need to get out of there in a hurry. That's why she had to get out of the car. They were expecting trouble, bad things, something. Quenisha and the defendant both provoked the people in the house. You saw those upstairs windows, they're open. Everybody in the house is hearing exactly what's going on outside that house. Rachel, in opening statement, said they're circling like sharks. That house was under siege. And the people in the house were scared, and we know they were scared. The kids were scared. They were terrified when the officers got there. Tyshawn was scared. He's calling his mom. He's calling his grandmother. You heard from, I think it was Detective Wilson, that the grandmother, Sabrina, said she was on her way home before the police got there because she got these panicked calls. There are people outside the house. Torner was scared. Quenisha and the defendant got there with a plan to provoke a confrontation. They did different things. The defendant had a gun. We do not have proof that Quenisha's hand was on that gun. The defendant chose to pull the trigger 13 times. They were there. They were part of a criminal enterprise. They had designed to do exactly what they did. And the judge will give you things that you can consider: presence at the scene of the crime, companionship with another engaged in criminal activity, failure to oppose the commission of the crime, course of conduct before, during, after they planned it, and then they covered for it together afterwards, covered it up together afterwards, or tried to. The rest of that sentence is: an accomplice is criminally responsible for all acts committed by a confederate, which are a probable and natural consequence of their actions. That's it. If you boil this case down to a nutshell, is what happened to Anisha, is what happened to Torner a reasonable, foreseeable consequence of what he did? And the answer to that is an easy, resounding, definite yes. Therefore, he's guilty. It's that simple. Self-defense is a joke in this case. It's almost offensive that with a straight face, the defendant submits self-defense as a reason to find him not guilty. Number one, you have to believe his testimony on the witness stand, and you have to interpret the video that way, which doesn't make sense. But number two, legally, think about what the judge read to you. What is self-defense? What do you have to find? He had a right to be there. Done. We're done. That's it. That's the end of self-defense right there. You don't have to go any further. You can, there's lots of other reasons why it doesn't work. You have to find it because of the place he would have a right to be. He had no interest in that property whatsoever, and he was there for inappropriate reasons. Okay, next up, did he act without fault? No, we're done. Self-defense is gone. Just gone. Not even close. Did he act without fault? He's calling Turner out for what, 5 minutes? I'll paint this place up. I'll kick it in. I want you to come out. They're throwing bricks through the window. He's trying to push his way past a, what, 6, 7, 8-year-old kid to get into the house? You have to find he acted without fault. And you don't get to cut it that thin. There is less than, what, second, 2 seconds between the last time the defendant says, I want you to come out, and when Turner comes out the door. I noticed when Mr. Barfield froze the video there that last time, Turner's arm isn't even completely extended when the defendant is turned around, firing back at the house. Did Turner have a gun? Yeah, he's defending his house. His house, his family's house, his family members, the kids in that house. If anybody had an opportunity to avail themselves of self-defense, it's Turner. Turner did not come out shooting. He could have come out of that house with guns blazing, been ready to fire the second he walked through the door, and he didn't. He didn't. There's no fight or flight or freeze moment from him when Turner comes out that door. Not for a split second. There's no fumbling with the gun. There's no flipping off a safety. There's no racking around into the chamber. He's ready to fire, and he's been ready to fire since he pulled the gun out of his pants after he tried to push his way into the house. And he fired. Immediately, without hesitation, 13 times until the gun wouldn't fire, and then he ran away. 2 people are dead as a natural and foreseeable consequence of every choice he made that day. And he knows it. You saw his testimony on the stand. There's no fight there. He answers every question Rachel asked him. Yeah, including the ultimate question. If you hadn't done what you did that day, Anisha's probably still alive, right? He says, yes. He knows. He absolutely knows. And he knew that day, because we know what he did after. And every step he took after he emptied that magazine towards the house and took Turner's life and caused Anisha's death is consciousness of guilt. He knew what he did was absolutely wrong. Took a gun to the house, had a getaway driver. He fled the scene. He doesn't call 911. If he didn't do anything wrong, you get to a safe distance and you call 911. We know he had a phone. He didn't do that. He gave his phone to Quenisha. The police track it. He probably knows they can track it. So he ditched his phone. He ditched the gun. He got rid of the gun someplace. He says he doesn't know where it is. He must have dropped it. Nobody's found it in the intervening time. And then when he turns himself in the next day, he says, I turned myself in because check me. I knew you guys had me. And if I have to do time for this, I will. He knows. He knew in that moment. He knew immediately afterwards that he had done criminal things. So, read the law as the judge gives it to you, as you have in your packets. Not what I say it is, and absolutely not what Mr. Barber says it is. Look at the facts, the video, and ask yourselves, is what happened that day on all of these counts a reasonable, foreseeable consequence of the defendant's choices? And once you answer that question, yes, which is the only answer possible given the evidence in this case, he's guilty of the charges that he's facing. Actions have consequences, choices have consequences. When you go to a house armed with a gun, you try to confront someone in the house. He knew there was a chance he'd be sitting in a courtroom like this in front of the both of you. So, On behalf of the state of Indiana, on behalf of the victims' families who you met a couple days ago, representatives from those families, on behalf of the law, but especially on behalf of the credible evidence in this case, we ask you to find the defendant guilty, to hold him accountable for the choices that he made, and you won't be telling him anything he doesn't already know. Appreciate your attention to the course of the trial. Thank you.
Thank you, Mr. Chair.